I'm the co-founder of Arbitral Women. And first of all, I want to thank Janet Walker and Donna Sertani for their amazing efforts, and all the team for their amazing efforts in putting this together. It's thrilling to see such a big crowd, unexpected, and very, very happy to see so many people here. We have a very interesting, I hope, very interesting to you panel to come. But first, a word about Arbitral Women. We are a group of 1,200 members, 1,200 plus now, growing every week in 40 countries, women promoting women in international dispute resolution. We started it in 1993 when, if they had statistics then, you would have seen that the number of women appointed as arbitrators was 2%. And looking in this room now, I see that we're well above that. Not perhaps at parity, but well above it. And let me tell you just a little bit about what we've been doing in the last 30 years since we began in 1993. Our website, Arbitral Women website, has a searchable member directory, a find practitioners section. These are great for people who are looking for talent and want to find women with those talents, and also good for our members to find each other as well. Arbitral Women have an opportunity to publish, both in our newsletter and on the Kluwer blog. We promote your speaking engagements on our events page and our social media. We present organized events, either by us or by you, and if you have an idea, you can come to us, as happened here, and we will help to put it together. You can tell us about your promotions, your awards, your achievements, so we can showcase them on our social media and our news page. Our member mentorship program is very popular for newish arbitrators of any age. We have a parental member mentorship program as well. YOP, our Young Arbitral Women Practitioners, is a very dynamic program for the under 40s. Arbitral Women SpeedNet is our version of speed dating. It's a quick and efficient networking opportunity, and it's a lot of fun. The Arbitral Women Diversity Toolkit helps you make your own world more inclusive. Our educational funding program has funded projects by Cambodian Legal Education for Women, the VIS East Capacity Building Program, and Arbitration in Africa thus far, and we're open to new projects. We partner with other like-minded organizations around the world, including CIR, AAA, ICDR, REAL, Arbitration Place Here, the ERA Pledge, and more recently the ERE Pledge. You'll hear more about the ERE Pledge from Tara Singh, our moderator today. And turning that now to this, Tara is the leader of FTI's Canadian Valuation and Damages practice based in Toronto, and for more than 17 years, she specialized in the assessment of economic damages and valuation of businesses and other assets, particularly in the context of complex commercial litigation and arbitration. She's handled breach of contract, intellectual property, securities fraud, class actions, and lots of other things. She's a testing expert and has prepared expert and evaluation reports for submission to Canadian, US, and international courts and arbitral tribunals. And her industry casework includes manufacturing, real estate, energy, and telecommunications. So Tara Singh, one of today's moderators, I now yield the floor and the microphone to you.
Thanks, Louise. So I have the pleasure of introducing the remaining panelists, but I'll start with my co-moderator. So we have Becky Seidler. Becky is a partner of KPMG LLP and a senior vice president in KPMG's forensic practice based in Toronto, and she's been with KPMG for 20 years. She specializes in the analysis and quantification of financial losses for litigation purposes, performing complex and multinational forensic accounting investigations, and advising on fraud, risk management, ethics, and integrity. Becky holds various leadership positions at KPMG and is currently the National Dispute Advisory Practice Leader, National Forensic ESG Leader, and National Forensic Training Leader. I'll introduce the remaining panelists in alphabetical order. So jumping to Katie Gosnell is a senior director at Kroll and has 10 years of experience in the business valuation and litigation disputes practice. She has prepared and critiqued expert valuation and other reports quantifying financial loss and damages pursuant to a variety of litigation and dispute matters, including breach of contract, shareholder dispute, expropriation, and other types of engagements. Maureen Littlejohn, to Katie's left, is a partner at Davies, Ward, Phillips & Weinberg, one of Canada's leading business law firms. Her civil litigation practice focuses on complex commercial litigation and alternative dispute resolution. She works with Canadian and international clients across a broad range of industries, including construction and infrastructure, mining, and telecommunications. She is recognized by Chambers Canada, Benchmark Litigation Canada, and the Canadian Legal Expert Directory for her litigation expertise. To my left is Lorna Tardif, holds an MBA, is a registered professional engineer, is a partner at HKA, and has over 35 years of experience in expert testimony, claims consultancy, dispute resolution, and project advisory services across the construction industry. Lorna has been retained as an independent expert on more than 200 occasions by owners, contractors, design professionals, and financial institutions. She's given expert witness testimony before courts and arbitration panels across Canada and in the US. And last but not least, Lauren Tomasic. I'm going to do that several times today, so I apologize in advance. Lauren is a partner in the ILSO litigation group and a key contact for the domestic and international arbitration group. Lauren has significant experience with domestic and international arbitrations under a variety of procedural rules and with ad hoc arbitration. She has acted on numerous significant and highly confidential arbitrations involving construction and infrastructure, mining, technology, and post-close issues in M&A transactions. She's active in the arbitration community and sits on the board of ADRIC, on the ICC Canada Arbitration Committee, and is a past chair of the Advocate Society Arbitration and Mediation Practice Group. So obviously a very accomplished set of women in front of you. So with that, I'll pass the floor to Becky and she'll get us started.
Thanks, Sarah. Just before we get into our first demo here, I wanted to give a brief overview of what we're going to cover today. So we're drawing on real-life fact patterns and situations to demonstrate and unpack current issues and cross-examination. This will be a bit of an exaggerated demonstration, but we hope to bring a bit of an entertainment aspect to it as well. You know, we're right before lunch, so hopefully you'll learn something as well as be entertained as well. So in our first vignette here, our expert and counsel will illustrate a situation where a testifying expert is faced with addressing the issue of who exactly prepared their expert report and the potential impact on their testimony. As is commonplace for an expert to work with a team, I think we can all agree that this is not necessarily a new issue, but that being said, the issue who contributes to an expert report and the actual disclosure of this fact has received some attention recently, including in a matter that Ms. Bosma was involved in. So our panelists will now do 2 short demonstrations on how the situation could go on cross. After the demo, we'll do a debrief, including lessons learned and key takeaways from the panelists' recent experience.
Ms. Gosnell, I'd like to start by asking you some questions regarding your analysis in Schedule 4. Can you turn that up, please?
Yes, let me see. Okay, I did not prepare this schedule myself, so I just need a minute to familiarize myself with it.
You didn't prepare the schedule?
No, my associate Jason did.
And you did not take steps to familiarize yourself with Schedule 4 before coming to testify today?
Well, I looked at the schedule before I signed the report. It's a type of analysis that I performed plenty of times before.
Ms. Gosnell, you're listed as the sole author of this report, correct?
Yes, that's correct.
You did not list Jason as an author of your report.
Well, that's right. I'm always supported by a team for a mandate like this. This is standard industry practice.
In fact, you did not disclose anywhere in this report that you had assistance in preparing it, correct?
No, I don't believe I used those specific words, no.
You have not enclosed a CV for Jason?
No, but Jason is a member of my team. He's a chartered business evaluator and he performed this analysis.
So you have assessed Jason's qualifications to do this analysis?
Well, that's right. I only hire the top associates to be part of my team.
But you've given this tribunal no opportunity to assess Jason's qualifications. Would you agree?
Well, I guess that's true, but he is a CBD.
What other analysis in your report did Jason perform?
Well, he prepared all the schedules in my report.
All of the schedules?
Yes,
Ms. Gosnell, these schedules are the basis for the expert opinions contained in your report, correct?
that's correct.
And you played no role in preparing them?
Well, that's not true. I reviewed the work and the analysis prepared by my staff, and I trust my staff, and the output looked reasonable.
It looked reasonable.
Yes,
Let me take you to Exhibit A of your report.
okay?
This is your signed Form 53, is that correct?
Yes,
And in this Form 53, you acknowledge your duty to provide evidence in relation to this proceeding that is fair, objective, and nonpartisan.
yes,
You also acknowledge your duty to provide opinion evidence that is related only to matters that are within your area of expertise.
yes,
And you signed this Form 53 to show that you're bound by these duties, correct?
yes.
Jason has not signed a form acknowledging these duties, has he?
No, he is not, but the conclusions contained in my report are my own.
Ms. Gosnell, if the numbers in the schedules in your report changed, your opinion might also change. Isn't that fair?
Well, yes, that's fair, but as I said, the numbers look reasonable.
Okay, well, let's go back to Schedule 4. You'll agree with me that the cash flow forecasts that you used in this analysis come from the first document listed in your scope of review.
Yes, that was the source of the cash flow projections I cited in note 2 here.
And those were the only cash flow forecasts you received and reviewed from management.
Yes, that's correct.
And if there were other contemporaneous cash flow projections prepared by management, you would have had to consider those projections in preparing your analysis.
Well, yes, but the set of cash flow projections I cited were the only ones management provided to me.
Okay, let me take you to your scope of review. You disclosed at the top, these are all the documents that you reviewed and relied upon in preparing your report, correct?
Yes, that's correct.
But you, let me take you to document 6 of your scope of review. Do you see that?
Yes,
You see it on the screen before you?
yes,
Would you agree with me that this document also contains cash flow projections on the second tab of the Excel workbook?
yes, I see that now. I guess I didn't see that when I was preparing my report.
Okay, and I guess Jason didn't see them when he prepared the schedule either, correct?
Well, I guess so. I'm not sure. I would have to speak with Jason.
You don't know, is that fair? You don't know whether Jason reviewed this projection and decided it did not need to be included, or whether he just missed it.
I suppose not. I'm not sure which one.
Okay, is there any reason from a valuation perspective that you would not have included this schedule?
No, I unfortunately didn't see them, so they didn't make their way into my analysis.
Okay, now if we compare the cash flow projections in this document to the ones that you used at Schedule 4, you'll agree with me that they're 50% lower.
I haven't done the math on that exactly, but it looks right, yes.
So had you incorporated these cash flows into your analysis, your valuation conclusion would have been lower, correct?
Well, yes, it would have.
By how much?
Well, I don't know. I haven't run those numbers, but by some amount.
A material amount?
Likely, yes.
So would you like to retract and revise your opinion of the value of the company based on the information in document 6?
I'm just not sure. I don't know why Jason didn't use these numbers. I guess I'll have to talk to him, and I could tell you how the projection impacts my opinion.
All right, thank you, ladies. So as we can see, it's quite obvious that we're in the situation, got into an uncomfortable situation by just not having enough involvement in the file that would be expected of them. Not only did they not do enough work, but there were key aspects of the basis of the opinion, including determining which source documents to consider and rely upon. They were actually performed by another team member. So let's take a look at this situation, how it could be different, and give Katie a chance to redeem herself.
Ms. Gosnell, let's turn to Schedule 4. This is your calculation of normalized EBITDA for Phony Corp, correct?
Yes, that's correct.
I noticed that your report is co-signed with Jason Johnson. Did you personally prepare this analysis?
No, I did not personally prepare this analysis, but I did work with Jason, who assisted. Jason Johnson is a senior member of my team, and he prepared the schedule. We provided Jason's CV, and he's signed an acknowledgement of expert's duty.
But Jason's not testifying in support of this report, correct?
No, that's correct, but I'm fully prepared to speak to this analysis. Before our report was finalized, in order to satisfy myself that I could rely on his analysis, I undertook a detailed review of the schedule to confirm that the cash flow numbers were consistent with the 2 forecasts I relied on, which were prepared by management, and mathematical accuracy of the schedule. I used my own professional judgment to select a normalized EBITDA of $2 million. I can fully support the conclusions on the schedule, and I adopt them as my own.
Okay, well, let's go back to Schedule 4. You'll agree with me that the cash flow forecasts used in this analysis come from document number 1 in your scope of review?
No, that's not quite right. As described in footnote 4, the cash flow projections were prepared using documents number 1 and 6. I took into account all the cash flow projections contained in the documents I reviewed and relied upon, which are listed in my scope of review. However, I determined based on my professional judgment that the cash flow projections in document number 1 were more reliable for purposes of this valuation. I understand projections in document number 1 were prepared for and presented to Phony Corp's Board of Directors, whereas the projections in document number 6 provides a much earlier back-of-the-envelope type of analysis.
Okay, thank you for that clarification. If there were cash flow projections that you'd been provided that were lower, would that have impacted your conclusions?
Well, to be clear, I took into account all cash flow projections of the company that were provided to me. If there were additional cash flow projections that have been prepared, I would need to conduct necessary due diligence in order to determine to what extent I could rely on them. I would need to discuss the preparation of those cash flows with management. I would need to undertake analysis to determine to what extent, if at all, these cash flow projections were necessary and reliable. But to be clear, I requested all the cash flows projections prepared by the company, which were contained in documents 1 and 6. So now I considered both sets in my analysis.
Okay, if the tribunal disagrees with your decision to rely on document number 1 and finds that document number 6 provides the more reliable projection, that would impact your ultimate conclusion, correct?
Yes, it would, and I acknowledge that assessment is ultimately for the tribunal to make.
Great, thanks ladies. I think the contrast between the two approaches is definitely clear, and we would all prefer to be working with the second expert. Now let's dive into some of the key takeaways from both expert and counsel perspective. So first, a practical matter, who actually does the work to prepare the expert report? Maureen, what is your perspective and expectation on the distribution of work between who's actually carrying out the analysis and writing the report?
This is obviously very fact specific. If you've got an expert mandate that's going to involve a lot of working with raw data, work that's more mechanical in nature as opposed to the expert applying professional judgment, I think everyone expects that that work is not going to be performed by your top billing rate testifying expert. But when it comes to applying expert judgment, if the expert is not doing it herself, the expectation is that the expert, by the time she sits down to testify, is fully prepared to endorse the opinion that's given and the approach that's taken.
Katie, from your perspective as the expert, how does this actually compare what Maureen said to what's done in practice?
I think it compares really accurately and is really representative of what is done in practice. Like Maureen alluded to, the top billing rate testifying expert is not oftentimes in the nitty-gritty of data compilation, et cetera, but where areas of judgment and areas of analysis, consideration, those types of things are involved, oftentimes that's when a testifying expert would be involved in making those types of decisions.
So the expert in the first scenario was not only unprepared, but probably outside their professional requirements. Some of these practical restrictions on who's actually doing the work are built into professional standards. Can you expand on those professional obligations and to actually review and supervise the work?
Sure. So as we alluded to in our scenario, when an expert does prepare a report, they sign a Form 53, which is a form required by experts, and it binds them to provide evidence which is fair and objective and nonpartisan in nature. And I think it's possible to achieve that type of expert evidence through appropriate and diligent review and supervision of the staff and the work product that they prepare. So it really goes to the extent of your review and your preparation when preparing the report and testifying.
I think that when you're dealing with valuation experts in particular, or other type of experts that are engaged on the regular, all they do is litigation mandates, the expectation is that this is what the workflow is like. But if you're dealing with more niche standard of care experts, it's worth re-emphasizing this to them, that by the time they sit down, they need to be able to speak to absolutely everything in the report, or they risk their entire conclusion being undermined on cross-examination, because it's not necessarily intuitive to experts who don't do this every day.
Yeah, that's a fair point on the difference. I think the experts on the panel here all work at firms that have rigorous review processes that have these QC built in and be well familiar, but good point on the contrast there. So it's often a team working on the report. We've established that. How do you actually determine as counsel who should be the testifying expert, who do you cross, and who do you prepare to stand in front of the report?
So it would be rare in my experience to retain just a firm. Like, you go out looking for a particular expert and you vetted that expert not only in terms of the scope of their expertise, but the treatment that expertise has been given by courts and to the extent that it's publicly available by tribunals. And so the expectation from my perspective is the person that I retain to be the testifying expert will in fact be the testifying expert. And it's only if something comes up during the course of the mandate that we weren't expecting. For example, there's a niche tax issue that feeds into the opinion that's given that our expert really can't speak to, that we would potentially look to expand that and have a second testifying expert in the same mandate.
So Katie, once that expert is determined, what tips do you have for counsel to help prepare the expert for testimony?
So I think it kind of depends on the amount of experience that the testifying expert you've selected has in preparing expert reports. I think for a lot of the firms who are sitting here today, and for my fellow panelists who have done this, routine as part of their day-to-day job, it's really an opportunity to collaborate with your counsel and understand what areas of the report are likely to be addressed or attacked in cross-examination, both from a legal perspective, but also from the greater context of the matter at hand and what issues are particularly hot button or contentious for a given matter.
How much time would you say you actually spend working with counsel in advance?
In advance of being crossed, it can really depend on the nature of your report. In some cases I've been a part of it, it's limited to a 2 or 3 hour kick around some concepts to full days of mock cross exams and take away answers, consider them, full comb through your report. So it can really vary.
Let's talk about the documents that were used in the example. In this scenario, the question over the level of the expert's involvement actually extended into determining what documents were considered by their analysis, or really what we consider the scope of review. So Katie, as an expert, what are your views on who should determine what documents are in scope and their reliability?
So from a strictly preparation of the scope of review listing that's included in the report, that should include all the documents you referred and relied to on the report. So it is a simple matter of collecting the documents that you reference and you cite and rely on. More broadly though, in determining what documents you review and rely upon, the assessment of the inputs into your analysis and your work product is critical. Like, we've all heard the expression here, garbage in, garbage out. And so from my perspective, it's really a matter of collaborating with your team as a testifying expert to identify the documents, identify and consider each reliability, and what ultimately leads into your report.
Anything else to add on that one?
Yeah, I'd say that, the position that I never want to be in as counsel is my expert is on the stand and is asked, is there material that you would have liked to see and didn't? And the answer is yes. So I think it's an iterative process. The expert's going to tell you, these are the types of documents we need in order to give the opinion that you're asking us to give. But the expert doesn't know what you have. So, the expert is going to ask for categories of documents, but once you get into the report writing phase or even the analysis phase, if there are documents out there that are outside the scope of what they've asked for, but that might bear on the opinion, it's incumbent on counsel to make sure that they have that. So the expert can sit there and say, everything I asked for, I got, and I'm satisfied with the result at the end of the day.
The other tip I'd add to that is involve your expert early, then they can identify which documents may be relevant very early on in the process instead of later.
and make sure the other side doesn't get them first.
To close out this issue, let's talk about best practices with respect to disclosing the jointly prepared reports. That was actually an issue in a recent case where it was concluded that the plaintiff was deprived of the opportunity to take this knowledge of contributing experts into account in the litigation strategy leading to trial. And also that the involvement of that contributing expert was not even disclosed until trial. It's a different setting, but same concept. And there was actually no mention of that contributing expert in the reporting question. So, for example, does everyone who worked on the file need to sign that Form 53, or is there any specific wording that you'd expect to see or any other sorts of best practices for experts to consider?
So no, I wouldn't have thought that everybody who works on the report needs to sign an acknowledgement of expert's duty. Certainly your testifying expert does, but there's a bit of judgment involved beyond that. The case that you're talking about was a case that happened under the federal courts rules, which has a particular code of conduct for testifying experts. And in that case, one of the things that was required under the code of conduct to be disclosed was if you did investigation or testing of your conclusions, you have to disclose who did that investigation and testing and what their qualifications were and whether the other side had the opportunity to participate. So there was sort of a niche issue there where the expert had used her PhD student to do a bunch of testing and vetting of her analysis and conclusions, and tried to rely on that in cross-examination, but had never disclosed that this student had been involved or what the student's qualifications were. But ultimately, it's an issue of judgment, as most of these things are.
Yeah, I would certainly echo that. I mean, I don't think it's a surprise to anyone in this room that oftentimes expert reports are prepared in a team setting. I think it's clear, or it's incumbent upon the report author to simply be clear about if you did work in a team or if you did the work by yourself, just be clear about to what extent you leveraged your team. In terms of signing a Form 53, like Maureen said, I think it's a judgment issue, and it depends on the level of contribution made by certain members of your team, to what extent they were making those types of judgment calls, judgment decisions. If that rises to the level in which they should be potentially co-signing a report and signing a Form 53 as well.
But I think, you take the sting out of that whole first line of cross-examination by just disclosing, I prepared this with the support of the team who did, primary data analysis that I then, checked and confirmed and adopted.
Yeah, makes sense. I know at KPMG we have standard wording that we put in there, just to your point, to get ahead of it. Right. Are there any, before we wrap up, are there any other key takeaways that you or the other panelists want to leave the audience with from this demonstration?
I mean, I guess I'd just say, like most of what happened in that cross-examination demonstration, the foundation was laid from the beginning of the mandate. So dealing with these issues up front in the mandate is critically important for what ultimately happens on cross. Because if your expert wasn't actually involved in preparing the report, there's not a lot you can do by the time you get to cross-examination prep to fix that.
Yeah, and just from an expert's perspective, it's the mirror of what Maureen just said. It's being clear and direct in your report about what was done by you, what was done by a team, and at the end of the day, ensuring if you are the sole expert and you are the sole author, that you can stand by every line item that is contained in your report.
I just had a comment about Form 53, which Ontario lawyers in the room are going to know that's a construct of our Ontario Rules of Civil Procedure. And in the international setting, in international arbitration, the Rules of Civil Procedure don't apply, and that type of acknowledgement doesn't necessarily apply. So 2 things about that is, 1, I have retained an Ontario expert in the context of an international arbitration and thought it was a good idea to have a Form 53 signed, right? Makes sense. Well, that's something that I see people shaking their head. It's not required, and it actually can really be picked apart in the context of an international arbitration by individuals who see this and think this is interesting. I can ask questions about this expert on every single element of this form, whereas Ontario practitioners, we might take it a bit for granted. So I just sort of throw that out there for consideration in international arbitration setting.
So in that case, the CV of the expert is enough?
Well, I mean, that's the thing. Who knows, right? I mean, it's you want some assurance that obviously the expert is independent and whatnot, but what does that look like? Is it something that you want to agree upon in advance in a procedural order? Is it something that you want to put out there and have your expert be prepared to defend, which is okay too? But I would say just be prepared and be mindful of the fact that a Form 53 is going to look different to an international lawyer, and they will do what they may with it in that context.
Even where it's not required in international arbitrations, we typically have something that hits those points, right? Whether it's a couple of paragraphs in the report or something that kind of looks like a Form 53 but doesn't actually have it, because those things should be acknowledged by the expert no matter what forum you're in.
Okay, thank you so much. That was really helpful. I will now move us over to our next vignette, where our expert and counsel team, Lorna and Lauren, will address the use of demonstratives during the hearing. So I think similar to what we discussed in the last demonstration, this is not a brand new topic, but what I'd argue is that the issue is somewhat changed or modified by external factors. And what I mean by that is, we're living in this world of big data and the Internet of Things, and there's just so much information that's coming at us left, right, and center. And I think as we'll see in this demonstration, that idea of information overload can sometimes creep into an expert's work, and with potentially disastrous consequences. So what we'll see now are two demonstrations, both what we'll call the bad and the good, of how this issue can play out in a hearing. So if we get the first slide.
Good afternoon, Ms. Tardif.
Good afternoon.
In your direct testimony, you presented Exhibit 6 to the arbitration panel, and that's what we see on the screen. Is that right?
Yes, it is.
Now, to state the obvious, there's a lot of information in this exhibit. Is that fair?
Well, we certainly wanted to make sure that the panel had in one place all of the data and all of our analysis and all of our conclusions relating to this issue, which is complex. It's not a simple issue.
Okay, so your evidence is that this diagram contains all of the relevant facts, analysis, and conclusions of your expert opinion?
Yes, it is.
And I take it you prepared the diagram such that the tribunal could understand what your opinion is and essentially to provide a picture of what you were asked to apply on it. Am I to take it that that was the case?
Yes, that's the idea.
And I believe your evidence was in chief that you intended this to reflect your opinion on the impact of owner cost delays on this project. Is that right?
Yes.
Okay, so I want to break down this exhibit as I have some doubts as to whether that's the case. So let's look at your legend, and we have a bunch of bars in different colors there, and I see production is noted in green. Is that right?
Yep.
And then I see a bunch of other different colors of bars, and I see these are meant to represent shifts. I see we have shifts in units, cumulative units, and totals. Is that right?
Yes, that's correct.
And I'm looking at the measurement on the right-hand side of the graph, and I see what looks like is that cumulative units that's meant to represent.
Yes.
And you don't actually see the left-hand side of the graph even showing what measurement this is supposed to represent at all. Could you tell me what the left-hand side of the graph is measuring?
Well, we thought that would be obvious to you that that's units. I mean, there's only so much space here, so we had to cut out some things.
Okay, so it's supposed to be obvious to me that that's units. Got it. Now, I took you to the bars that are at the top of your graph there, and some, in fact, you told me were meant to delineate single unit measurements, correct?
Yes.
And you just told me that the left-hand side of the graph is also measuring single units, is that right?
Yes.
And it doesn't explain how the tribunal is supposed to delineate between the bars showing single units and the actual measurement showing single units. Is that fair?
Well, remember that I went through all of this in my direct testimony, and I keep emphasizing the complexity of this and how much information there is. We did take certain shortcuts putting this together in order to get it all in on one chart. But if you go back to my direct testimony, and it's all there.
I see. So maybe let me try that again with cumulative units. You told me that we have cumulative units measured on the right, and we have some curve that you are telling me are cumulative curves. Now, we don't, again, see how that's supposed to fit together, do we?
Well, go back to what we're trying to do here, which is to make the panel understand what the impact was of these owner-caused delays, and at the same time show you all of the data and all of our analysis. And it's there, it's in there.
Okay, so owner-caused delays. Let's go to that. That's what you told me you're trying to reflect, is that right?
Yes.
And I'm looking at where you say that there are 2 periods that were impacted by owner-caused delays, but am I supposed to be looking at the cumulative units, the single units? I don't see where the owner-caused delays is coming out. Can you point me to it?
Well, if you read all the detail in all these little boxes, eventually you'll come to it in there somewhere. Let me look here now. It's there.
Okay, let's try to simplify this. You told me earlier that the green bar was meant to represent production. Is that right?
Yes.
And your opinion was that there was an impact caused by owner delays on production. Is that right?
Yes.
And if I look at the green bars that are noted across this chart, I don't see any meaningful trend in respect of production. Isn't that right, Ms. Tardif?
Well, again, I guess it's how you look at it. I mean, I can kind of see it, and it's not just the green bars. You also have to look at the other colors of bars. And I know we didn't use the word production everywhere, but I mean, I can go back and walk through my direct testimony all over again if you want to try and explain it to you.
I mean, I don't think that's going to be necessary. I'm going to put it to you that this exhibit doesn't actually reflect any finding, opinion, or conclusion at all about owner-caused delays. It's simply a bunch of measurements that you've tried to show in the same place. Is that not correct?
Well, that's what you see, I guess.
So let's move on to some of the data that you've included in this very helpful chart. You note that the impact period was 491 units per week in the first unimpacted period. Is that right?
Yes.
Now, I'm looking at page 327 of your expert report, and I see that exact same period being referred to here, but I see that the impacted period is noted here as 319 days. Is that right?
Oh dear. Oh my goodness. That doesn't make sense. I guess the AI program we used to check consistency didn't work. Oh dear.
AI, it doesn't state anywhere in your report that you've used AI to do anything in respect of this report, does it?
Well, no, I didn't think it was important to tell you that.
Oh, why not?
Well, AI, spell check, it's all the same, you know.
All right, well, your AI doesn't seem like it did a very good job, did it?
Well, I don't know whether it was the AI that didn't work or my colleague who was supposed to do this who was asleep at the switch.
All right, looking down at the bottom of this graph here, I see you've delineated issues with the quality of material provided by the owner, and that was something you said impacted one of the periods you analyzed. Is that right?
Yes.
And where in your expert report can we find your analysis that correlates to the quality of the material that the production rate achieved?
Oh, I don't think it's in the report, but I remember my colleague telling me that he found it recently, some interesting information on this, and he thought it would be a good idea to include it, but it might not actually be in the report.
Okay. And Ms. Tardif, your CV identified your areas of expertise as being in delay and scheduling analysis in large-scale construction projects. Is that accurate?
Yes.
It did not identify any experience in analyzing quality of materials used as construction inputs, correct?
That's correct.
And so I take it you do not actually have that expertise in evaluating materials that are used as construction inputs.
No, and normally in a situation like this, we would speak with counsel and rely on expert testimony of a specialist in this field, but as I mentioned earlier, this is information that just came up at the last minute, and it kind of made sense to us, so that's why it's in this.
Okay, so you cannot actually speak to the import of owner-provided materials and whether that caused any sort of issue in respect of.
Well, it looks like it did.
Okay, but you cannot say that based on your own expertise, is that right?
Yes, that's correct.
And the Oscar goes to. So thanks for that. A couple of things jump out at me from this demonstration. I think firstly, this demo hints at some of the issues we talked about in the first demonstration, which is namely the importance of ownership of work product and an expert ensuring that she knows everything that's gone into her expert report. Next, we obviously see how use of demonstratives can be somewhat of a double-edged sword, and especially if used improperly, as it was in this case. So while the intent appears to have been to provide a cheat sheet of sorts to the tribunal, it looks like it really accomplished the opposite, which was just to put everyone in a state of confusion. So let's see how this could have played out somewhat differently if things had gone the other way.
We put up our next exhibit, please. All right, good afternoon, Ms. Tardick.
Good afternoon.
In your direct testimony, you presented Exhibit 6 to the arbitration panel, which is what we are looking at on the screen, correct?
Yes, that's correct.
And as I recall, you stated that you prepared this exhibit for use during your testimony to summarize your analysis and your opinions related to damages incurred by the contractor. Is that right?
I did, yes.
And I see that the exhibit plots what essentially looks like production over time. Is that right?
It is.
And I want to look at each of these periods. And first, let's look at this ramp-up period that you've identified here as period A. You see that there?
I do.
And I'm going to put it to you that we cannot actually understand why you say that this is a ramp-up period based on the exhibit. Is that right?
Any form of production has a ramp-up period. This is not an ongoing process. This has a start and an end. It's also referred to in the industry as a learning period. We set it aside because it is not representative of what the contractor would have achieved on an ongoing basis once that ramp-up period was behind him.
Let's look at period B. You say that this is a normal time period with an average average production of 491 units per week.
Correct.
But I don't actually see how this could be considered normal production on the basis of this exhibit. Is that right?
The analysis in our report, which is done in accordance with recognized industry publications on what is considered acceptable methodologies, sets out all the events that took place during this period, allows us to conclude that there were no causes of loss of productivity that would be attributable to either the contractor or the owner, and hence this period demonstrates what would have been expected of this contractor on an ongoing basis had the conditions continued as they were during the period.
Okay, let's move on. Time period C, that shows lower production. You say, I understand your evidence is this was caused by events beyond the contractor's control, correct?
Again, yes, that's correct. And again, done the same way as we did for period B, a comprehensive analysis of all of the events that took place as documented in our report. We do see multiple issues, all of which are attributable to the owner, and we do not see any issues attributable to the contractor.
And then if we move to the next period, period D, we see again what you've termed to be normal.
Correct. Period D is very similar to period B.
And I'm going to put it to you that if you look at periods B and D, which have approximately the same productivity level, and then periods C and E have approximately the same, what you attribute as an owner-caused drop in production, isn't it odd that the levels are sort of the same where you say it's normal and not the same where you say there's some type of owner-caused impact?
If you go to the actual data, you'll see that the average production in period C is close to the average production in period E, but it's not exactly the same. Different causes at play, somewhat of a coincidence that the numbers are similar, but this is what the analysis showed.
And I understand that the analysis in respect of period E showed that this was attributable to material cost issues.
Yes, as you will recall from the addenda that we issued to our report, we did receive new information not long ago that allowed us to do this analysis. We've included that additional analysis as an addenda to our report. And in this case, because the issue is outside of my area of expertise, I also relied on the opinion evidence of a subject matter expert relating to the quality issue.
Okay, and that's exactly what I was getting at, is you're not actually a materials expert, are you, Ms.
No,
Turtle?
I'm not.
But yet you say that you can draw conclusions on the basis of owner-caused delays, notwithstanding this lack of expertise.
I'm relying upon the expert opinion submitted by Mr. Smith, who is the quality expert. He does have that expertise. I'm assuming that his opinion is valid. If the tribunal determines that his opinion is not valid, then it may change our conclusions.
Thank you.
Thanks very much. So it's quite obvious that a good demonstrative really accomplishes two goals. I think we saw that very clearly. I mean, firstly, obviously with the information presented being much less dense, it's easier for a tribunal and really anyone looking at the diagram to digest. Secondly, I think it also gives rise to a different sort of interaction between counsel and expert, wherein the expert just seems much more focused, much more prepared, and is really able to deliver the evidence in a meaningful way. So I wanted to unpack some of these issues a little bit more with our panelists. So Morna, firstly, from your expert's perspective, what are some of the key takeaways for preparation and use of demonstrative evidence? And I know you have strong feelings about it, which maybe you can use as a cue for your next slide.
So the concept here is less is more. And we actually play the coffee game. If I can remove something from a slide or an exhibit without taking away from the essence of it, then you have to buy me, and you prepared it, then you have to buy me a cup of coffee. And within the team, there are times when I actually get a week's worth of coffee out of one exhibit. It's quite a skill, and it's hard work to prepare a good graphic. And as you saw from this, it's really easy to get yourself in trouble. I prepared the bad graphic, and I didn't realize how bad it was, because you found things in it that I hadn't even seen. So these lawyers are pretty good at finding out what's wrong.
Yeah, just on that, this graphic is a fiction that Florida prepared. I said, prepare a bad graphic and I'll make up questions, essentially. So and you can see how easy it is to tear it apart on the basis of stuff you don't even necessarily, it's pulling this out, and I think the tribunal would have been left either confused or determining that this graph shows nothing, and so it can't be relied upon. So the more there is, the more there just is to question about, and that is, regardless of if the questions sort of go to the bottom line, and here they were actually able to, given the nature of the exhibit, it just really enables a questioner to call into question the expert's evidence if there's too much there.
I was hoping to queue up your
The next
slide,
slide.
but I don't see.
I think it's there. Yeah, this is it.
Oh, there you go.
So this slide has been rated as the best demonstrative aid ever created. Quite a statement. The interesting thing about it is that it was created in 1869. And what you're seeing here is Napoleon Napoleon's march on Moscow in 1812 and 1813. The width of the line, the beige line is his march to Moscow, the black line is his retreat from Moscow. The thickness of the line represents the number of men in his army. 1 millimeter was 10,000 men. And the point, of course, is as he marched towards Moscow, he suffered great losses. And as he returned from Moscow, he returned in the late fall and winter, his losses became even greater. The only other piece of information included on the chart is the temperature during his retreat. It was extremely cold, which contributed to the loss of life. This has been published, you just have to Google it on the internet, there's lots and lots of variations of this one out there. This is the original. I came across it in a National Geographic publication, and every time I see it, it just gives me shivers. So this is, I really think that it does a marvelous job of delivering a powerful message in a very concise manner.
Where's the temperature?
You see it at the bottom of the chart.
What's the vertical scale then?
It's not, it's a map. It's just a map. You do see a vertical scale for the temperature at the very bottom, and you can see it drops to minus 30 degrees. Again, this is the original chart. You're shaking your head?
I don't understand why, what the vertical scale is on the chart.
Okay, it's intended to be a map, so there's no vertical scale per se, other than the thickness of the two lines.
That's the number of men.
Yes.
And
Yes.
per millimeter.
Yes.
You know, 2 million guys over there and 20,000 return home.
Exactly.
I got it.
Yeah.
Get back to the first chart. He's an engineer.
Okay, thanks for that. Really quickly, because I think it will be fun and interesting to have this next discussion. Lorna, in your first demonstration, the bad one, I call it, you alluded to the use of artificial intelligence, ChatGPT. Can you tell us a little bit about what you're seeing in terms of tools and procedures using these types of tools to the extent that you are?
So we are restricted in its use for confidentiality reasons. Like everybody, I've been hearing all kinds of stories about its use in litigation. We certainly anticipate an exponential increase in the use of AI, not just in litigation, but in and expert reports, but also in project management, to the point that it will become like spell check, that you don't really have to mention it. It will be taken for granted that you're using those tools. I'm really looking forward to it, to be honest.
Okay, and then Lauren, from your perspective, one thing I've been hearing about is law firms are obviously deploying AI and using them to do various things, various activities. One of which is to bring together, collate legacy files, legacy matters, and obviously expert reports form part of the background detail that's preserved on some of these legacy matters. And one potential outcome, maybe unintended, is that expert reports could make its way into this generative AI platform and be used as fodder for the examination of an expert, basically comparing the expert opinion that was rendered 2, 3, 5, 10 years ago to the one that's being rendered now. Do you have any thoughts? I mean, again, setting aside privacy, ethics, all of those things, what are your views on whether that's fair or not?
Well, I think that we're all going to see both counsel and experts using AI to leverage cross-examination to come up with ways in which they can put things to the expert in order to trip them up in the traditional cross-examination sense. I don't think there's anything unfair about that, provided all the data, not even from a fairness perspective, but from an effectiveness perspective. I think everything is still very much in the stages where it needs to be cross-checked. I was asking my AI team in preparation for this presentation about certain tools that they thought that, might be worth mentioning or could come into play in the context of an expert report and a cross-examination. And their response to me was, well, there's a lot, but just make sure you're checking everything before you do anything, was their central message. As for the repository, I think that's interesting. I wonder about confidentiality, implied undertaking, where some of this information is coming from, and if any of it has been obtained through some sort of breach of confidentiality, either in an arbitration setting or through a breach of the implied undertaking. I think that's a problem. But as to where we're getting these sources of information, their reliability and what their underlying, repository of data is, I think that remains to be seen.
Thank you. I was hoping to open this discussion up to the audience, but I guess we'll leave that for the lunch break and you can discuss amongst yourselves. So that's basically the conclusion of the substantive portion of our presentation, and I hate to be the one standing between us and lunch, so I will be brief. However, I did think this was an excellent platform, quite literally actually, based on the panelists that we have here to tell this group a little bit more about the ERG pledge. If we could go to the next slide as we're doing this. So in recognition of the underrepresentation of female expert witnesses in disputes, members of the expert witness community and other stakeholders have come together to bring about this ERG pledge. And the official mandate, I think it's up there, is to increase access on an equal opportunity basis for the number of women appointed as expert witnesses in order to achieve fair representation. Obviously, the ultimate goal is full parity, and so we're working towards that. What can you, as participants in the community, do to help? I think organizations that are retaining experts or growing experts, really making sure that there's fair representation and access to opportunities as part of proposals or being put up as lead experts. And then as the parties to a dispute and counsel to these parties, making sure that there is fair representation in terms of the expert teams that are being proposed for these types of engagements. So just really being mindful of making sure that the opportunities are available for training as well as delivery of expert mandates. I will leave it at that. If you're interested in learning more, please do reach out to me, or you can actually sign up directly using this QR code, which I hope works, but it should. I tested it. So thank you so much. Thank you to all of you. I hope this was a useful discussion. I think what was really important for the panelists is cross-examination hasn't changed. These are fundamental tips, tricks, things that we will use all the time. Counsel's perspective as well as experts' perspective. But the way in which we're using these tools, demonstratives, AI, all of these things will evolve, and so we, as a community, need to evolve along with them.
I hope you will agree with me that as clear as the previous slide was as a demonstration, so too was this. I'd like to see a sea of panelists pointed at that QR code right now, so that you all go to it and sign up to the pledge. Now, we have just a few more, so thank you very much, ladies. That was really wonderful.